Contract Law Rules, Cases, and Problems, Second Edition, by Professor Seth C. Oranburg. Chapter 1 What is Contract Law? Our study of contract law naturally begins by discussing the nature, purpose, history, and evolution of contract law. Contract law's purpose is the foundation upon which we'll construct the scaffolding of contract doctrine. Contract law is the law of promises. A promise is an expression of a commitment to do or not to do something. Promises are the foundation of contract liability. Without a promise, there is no evidence of a voluntary agreement to be bound to. Contract law depends on this voluntariness. People create their own obligations under contract law. If you do not want to be liable, you can choose not to form a contract. Thus, there is no contract liability where there is no promise. Its voluntary nature makes contract law different from other types of law. Public law governs the relationship between people and the government. Public law, such as criminal or tax law, applies to everyone, whether or not they agree. You cannot opt out of paying taxes or following criminal laws without facing consequences. Some tax protesters have refused to pay taxes, arguing they never consented to them. Courts have consistently rejected these arguments, and many tax protesters have been fined or jailed for tax evasion. Contract law, by contrast, is part of private law. Private law governs relationships between people. It includes tort law, property law, and family law. Unlike public law, private law is mostly voluntary. Contract law is especially voluntary. It enforces only the obligations people freely choose to create. This focus on promises allows contract law to play a unique role. It enables individuals to make agreements they can rely on. This reliability supports both personal relationships and large-scale economic activity. As we study contract law, we will explore how promises create obligations when they are binding, and how law balances fairness with freedom. This will reveal why promises are essential and how contract law helps to structure modern society. Part A: Origins of Contract Law. The law of contracts is ancient. It originated in several ancient civilizations across the world. It is not possible to determine which civilization was the first to develop a system for enforcing contracts, but according to Professor Charles Auerbach, the oldest collection of contract law sources that are still used today was assembled by Rabbi Hillel in 200 BCE. The Jewish law of contract was derived from the 5 books of Moses: Genesis, Exodus, Leviticus, Numbers, and Deuteronomy, and Jewish oral tradition. Orthodox Jewish courts still apply these laws and principles today, although the divine principles underlying Jewish law are sometimes quite different from the philosophical justifications for law that are accepted by modern nations. The Roman law of contracts is no longer employed today, but according to Professor Alan Watson, it forms the basis for enforcement of private agreements in most of the Western world. The earliest embodiment of Roman law of contracts is probably found in the 12 Tables, a set of laws inscribed on 12 bronze tables that were created around 451 BCE. These tables have apparently been destroyed, but their legacy survived. Some countries, such as South Africa, still base their legal system on the Roman jus commune, or common law. England, although it was influenced by Roman law, did not adopt the Roman law of contracts wholesale. Roman law was introduced to England, along with the French language and other continental traditions, by the Norman conquest of 1066. But England at that time was not a legal tabula rasa, blank slate. Rather, commercial disputes were resolved in various local courts. This varied legal tradition, mixed with a Franco-Roman influence, was first canonized by King Henry II, who pronounced a unified national common law in 1154. After the English Magna Carta, Great Charter, was instituted in 1215 to provide for basic civil liberties and restrict the power of the monarchy, the English Court of Common Pleas was established to adjudicate actions between people, as opposed to actions which concern the state or the monarch. The English Court of Common Pleas heard contract disputes for hundreds of years, until it was finally merged with the English King's Bench, the Court of Chancery, and the Exchequer by the Supreme Court Judicature Act of 1873, more than 100 years after the American Revolution. The American legal system is heavily influenced by its English predecessor. Prior to the Revolution, the British government claimed to have the sole power to create courts in the American colonies. Courts in the American colonies generally borrowed from English law. You can even find citations to the King's Bench and other English courts in some early American case law. But even in this early period, when the colonies were still under English rule, the American courts began to develop their own precedent and approach. As judges interpreted and sometimes created law to fit the needs of American commerce, a uniquely American common law of contracts began to develop. Part B, Law and Equity. Contract law is historically rooted in two distinct legal systems, law and equity. While American state courts merged these systems during the 19th century, and the Federal Rules of Civil Procedure in 1938 unified legal and equitable claims in federal courts, important distinctions remain. For example, procedural rights, such as the entitlement to a jury trial, may depend on whether a claim is categorized as legal or equitable. Beyond procedure, these systems embody different philosophies about the role of contract law. Like many areas of law, contract law grapples with a central tension: the rigid application of formal rules versus the pursuit of fairness and justice in specific circumstances. Understanding the history of law and equity offers valuable insight into this ongoing balancing act. In 1215, King John of England signed the Magna Carta under pressure from rebellious barons. While the Magna Carta did not create English law, which arguably began in the Anglo-Saxon period, the 5th century, and evolved remarkably after the Norman Conquest, 1066, it codified the assertion that everyone, including the king, is subject to the law. Though the document primarily addressed feudal and political issues, it also laid foundational principles for contract law. Notably, Chapter 41 provided protections for merchants, ensuring their freedom to move and trade without interference. All merchants may enter or leave England unharmed and without fear, and may stay or travel within it, by land or water, for purposes of trade, free from all illegal exactions. By affirming that even the king was subject to legal constraints, the Magna Carta helped create an environment where contracts could be enforced consistently. These protections not only supported commerce, but also set the stage for the development of the lex mercatoria, the law of merchants, a precursor to modern commercial law. Among the Magna Carta's many provisions was Clause 17, which mandated that common pleas, civil disputes between private parties, a category we now refer to as private law, be heard in a fixed location rather than in the king's itinerant court. This provision ensured greater consistency and accessibility in the administration of justice. It led to the establishment of the Court of Common Pleas at Westminster Hall, where it became a central venue for resolving the disputes that defined medieval commerce and society. The Court of Common Pleas primarily handled cases involving property, contracts, and debts. It provided a structured forum for addressing breaches and enforcing obligations, playing a crucial role in standardizing legal principles for agreements. This standardization helped merchants grow commerce by providing predictability in contract enforcement. The court adhered strictly to procedural formalities and precedent, ensuring consistent and reliable outcomes. Its remedies, such as monetary damages, were central to the enforcement of contracts, offering a framework that supported trust and accountability in economic relationships. The Court of Common Pleas also contributed significantly to the development of common law, a body of judge made legal principles established through court decisions. Additionally, the court intersected with the lex mercatoria. Despite its name, lex means law, the lex mercatoria was not a formal statute or guild regulation. Instead, it was a system of commercial customs and practices created and upheld by the merchants themselves. These rules governed trade transactions across regions and were enforced informally through merchant courts and arbitration. Unlike the common law, which developed through royal courts and relied on legal precedent, the lex mercatoria was designed for efficiency and practicality, addressing the immediate needs of merchants engaged in cross-border trade. As commerce expanded in medieval England, disputes between merchants increasingly found their way into the king's courts, including the Court of Common Pleas. To address these cases, the Court of Common Pleas began incorporating elements of the Lex Mercatoria into its rulings. This integration helped bridge the gap between the informal, flexible customs of the merchant class and the more rigid procedural framework of the common law. By incorporating merchant practices, the court provided greater legal certainty for commercial transactions, laying the groundwork for standardized principles in contract and trade law. However, the court's strict adherence to formal rules and procedures often limited its ability to address the unique needs of merchants, particularly in cases requiring more flexible or equitable remedies. The rigid structure and formal procedures of the Court of Common Pleas provided experienced merchants with certainty and predictability when resolving standard contractual disputes. However, not all cases fit neatly within this framework. When common law courts failed to offer adequate remedies, particularly in cases requiring flexibility or fairness, also known as equity, individuals turned to the king himself by petitioning him for justice. As the number of these petitions grew, it became impractical for the monarch to address them personally. To manage this demand, the king delegated the responsibility to his chief minister, the Lord Chancellor. The Lord Chancellor, often referred to as the keeper of the king's conscience, reviewed these cases and provided relief based on principles of fairness rather than the rigid rules of common law. Over time, this practice evolved into the establishment of the Court of Chancery. Operating under the Lord Chancellor's authority, the Court of Chancery became a formal institution, addressing cases where common law remedies, such as monetary damages, were insufficient to deliver justice. This court played a pivotal role in developing equitable principles, which remain integral to contract law today. While the Court of Chancery addressed the shortcomings of the common law courts, its informality created challenges of its own. Unlike the structured procedures of the Court of Common Pleas, early Chancery proceedings relied heavily on the discretion of the Lord Chancellor, who often acted without clear guidelines or precedent. This informality sometimes resulted in inconsistent decisions, which made it difficult for parties to predict the outcome of their cases. Moreover, because the Lord Chancellor was not bound by the rules of the common law, critics viewed the court as arbitrary and overly subjective, which are hardly the hallmarks of equity. Petitioners often relied on their ability to frame their claims in moral or emotional terms, which raised concerns about fairness and impartiality. As the volume of cases increased, this lack of structure became increasingly problematic, highlighting the need for a more formal and systematic approach to equity. The early 16th century was a pivotal period for the Court of Chancery, marked by the contributions of two key figures, Cardinal Thomas Wolsey and Sir Thomas More. Both served as Lord Chancellor and were instrumental in formalizing the court's procedures and reinforcing its role in addressing cases where the rigid remedies of common law courts were insufficient. Their leadership helped shape the equitable principles that remain integral to modern contract law. Cardinal Thomas Wolsey served as Lord Chancellor from 1515 to 1529. Though not a trained lawyer, Wolsey recognized the importance of fairness in delivering justice. By emphasizing fairness over strict legal rules, he helped to solidify the Court of Chancery's reputation as the forum for cases where legal remedies, such as monetary damages, were inadequate. However, Wolsey's broader responsibilities as a political and ecclesiastical figure limited his ability to implement lasting reform in the court's operations. Sir Thomas More, a lawyer and humanist scholar who wrote the political novel Utopia, succeeded Wolsey as Lord Chancellor in 1529. More brought a new level of legal rigor to the Court of Chancery. His tenure focused on streamlining the court's process and ensuring greater consistency in its decisions, addressing criticisms that Chancery had been arbitrary and overly informal. Moore was a staunch defender of the court's equitable jurisdiction, particularly in cases involving contracts. He reinforced the use of remedies that common law courts could not provide, such as compelling parties to fulfill their contractual obligations. Moore established the foundations of modern contract law remedies, including specific performance to convey land, injunctions to prevent actions that cause irreparable harm, and rescission to cancel contracts formed under fraudulent or coercive circumstances. These remedies were essential in situations where monetary damages, the primary remedy in common law, could not achieve justice. Moore's contributions helped establish equity as a structured and reliable complement to common law, thus ensuring that contract law could address complex and unique disputes effectively and fairly. The American colonies inherited England's dual system of law and equity, with separate courts handling distinct types of cases. Courts of law resolved disputes by applying strict legal rules and offered remedies such as monetary damages. Courts of equity, on the other hand, provided more flexible remedies grounded in fairness, including specific performance, injunctions, and rescission. This separation meant that both the remedies available and the causes of action a litigant could pursue depended on the system in which their case was filed. After independence, some states maintained separate courts for law and equity, while others merged the two jurisdictions into a single court with the power to grant both legal and equitable remedies. Article 3 of the U.S. Constitution and the Judiciary Act of 1789 granted federal courts jurisdiction over both legal and equitable claims. Yet seeking equitable remedies required following different civil procedures until 1938, when the federal rules of civil procedure unified legal and equitable claims into a single procedural framework. This historical context underscores how American courts have preserved and adapted the principles of law and equity to meet the evolving needs of society, thus ensuring that fairness and predictability remain central to the legal system. It also demonstrates how American federalism impacts the evolution of law. Each state establishes its own contract laws and even its own court systems. As of 2024, Delaware, Mississippi, and Tennessee maintain separate courts of equity, known as chancery courts. These courts handle matters such as trusts, estates, guardianships, and issues requiring equitable remedies like injunctions or specific performance. The most notable among them is Delaware, which specializes in handling corporate disputes and fiduciary litigation issues. While the distinction between law and equity has thus been blurred, some differences remain. For example, equitable claims tend to require some element of justice, whereas a legal claimant may prevail merely by meeting the standards required by law. Many equitable remedies can also be limited as justice requires. This casebook will detail how this applies when we arrive at the remedies section. Moreover, equitable claims and remedies remain exceptional and extraordinary, meaning that courts will prefer to find a legal remedy and will only resort to an equitable remedy to the extent that justice requires them to do so. Because courts still regard equitable remedies as exceptional, they will not be granted when a legal remedy is available. Students are encouraged to analyze legal claims and remedies first. Only explore equitable claims and remedies as a last resort, presenting arguments for why justice requires imposing an equitable remedy, even in the absence of a legal one. Part C, the Restatement of Contracts. America began as a British colony that imported British law, including the law of contracts. After the American Revolution and the formation of the United States of America, American law began drifting apart from English law. In the early days of the United States, states had a great deal more power relative to the federal government than they do today. State courts heard most contract claims, and contract law developed as a matter of state law. State law may vary, as one state is not bound to follow another state's precedent. Thus, contract law developed differently throughout the states. The variations in contract law among states create some challenges for interstate commerce. Whether having different state laws and giving parties the right to choose among them is good or bad for commerce and society is the subject of much debate in commercial law. Theory aside, there have been practical efforts to generalize and normalize contract law among the states, some of which have been successful. The leading effort to define or create a common law that is truly common throughout America has been conducted by the American Law Institute, or ALI, an organization that was founded in 1923 to clarify, modernize, and otherwise improve the law. Today, the ALI drafts, discusses, revises, and publishes restatements of the law, which are treatises on what the law is, model codes, which are examples of what the law should be, and principles of law, which are studies of areas of law thought to need reform. The ALI's work is enormously influential in the courts and legislatures, as well as in legal scholarship and education. ALI restatements are frequently cited by American courts as statements of black-letter law, which are propounded to be statements of legal rules that are no longer subject to reasonable dispute. The first restatement of contracts, drafted in the 1920s under the leadership of Harvard professor Samuel Williston, aimed to codify the common law of contracts with a focus on legal formalism. It presented contract law as a set of clear, objective rules, emphasizing certainty and predictability. However, as American courts increasingly moved away from strict formalism in favor of a more flexible, contextual approach, the first restatement came to feel outdated. These shifts laid the groundwork for the development of the second restatement of contracts, which embraced legal realism and sought to address the complexities of modern contracting. The Restatement Second was drafted and promulgated in 1979 as part of a movement known as legal realism. This movement is based on the idea that law cannot be understood in a vacuum. Rather, law is a product of humanity and society. Practically, this approach means that a court must look for the parties' actual intentions when they entered into a contract, even if the plain meaning of what they said or wrote would reasonably be interpreted by a third party to mean something else. The second restatement was principally drafted by Arthur Linton Corbin, a professor at Yale Law School, who is sometimes credited with creating the modern law school model. Despite the Second Restatement's foundations in legal realism, it increasingly feels like a creation of an earlier age. For example, both restatements were created when virtually no one owned their own computer. Now we walk around with computers in our pockets, on which we can purchase goods and offer services. As the Second Restatement shows its increasing incompatibility with the digital age, a new restatement may prove to be necessary sometime soon. In addition, some scholars and jurists criticize the Second Restatement for shaping and creating, instead of merely reporting the law. But the law changes slowly. At present, the Second Restatement is still considered to be the best authority on what is the common law of contracts in America. We will rely heavily on the Second Restatement to learn contract law principles. Just keep in mind that the law of contracts will change during your lifetime of practice in the law. As a common law doctrine, contract law can change as judges create new precedent by deciding new cases. By practicing contract law, you can be part of that change. Part D, the Uniform Commercial Code. In addition to restatements, which serve as highly persuasive treatises on what constitutes black letter common law, the ALI also produces model codes. These are designed as templates for state legislatures to use in drafting statutes. In the American legal system, most contract disputes are governed by state law, meaning that each state is free to craft its own legal doctrines without being bound by the precedents of other states. While this system encourages legal experimentation and local optimization, discrepancies between state laws can create confusion and increase costs for interstate commerce. To address these challenges, the ALI developed the Uniform Commercial Code, or UCC, in 1952 in collaboration with the National Conference on Commissioners on Uniform State Laws. The UCC was created to harmonize commercial laws across the states, providing consistency for businesses operating nationally. The UCC covers much more than contract law. In fact, it is so expansive that each article could easily fill an entire law school course. This book, however, focuses exclusively on Article 2 of the UCC, which governs contracts for the sale of goods. Even there, this book only discusses the UCC provisions that substantively change the common law as found in the Second Restatement. This avoids confusion and keeps the course streamlined. Unlike the Second Restatement, which is a persuasive authority used to clarify the common law, the UCC becomes binding law once enacted by state legislatures. All 50 states have adopted some version of the UCC, and in doing so, have displaced earlier judicial doctrines that conflict with its provisions. Thus, while the Restatement Second advises courts on what the law should be, the UCC dictates what the law is in its area of coverage. Courts are obligated to follow the UCC when adjudicating applicable disputes. The question then is whether the UCC applies to a given contract. Article 2 of the UCC governs contracts for the sale of goods. UCC Section 2102. A sale is defined as the passage of title from the seller to the buyer for a price. UCC 21061. Sales are distinct from gifts, which involve the transfer of ownership without payment, and leases, which transfer possession and use of goods for a limited term without transferring ownership. Goods are defined as items that are movable and identifiable at the time the contract is formed. UCC 21051. This includes tangible items like a ton of bricks or a barrel of monkeys. However, the UCC does not apply to services, laying the bricks or training the monkeys. Nor does it apply to the sale of real estate, like a brickworks or a zoo. Yet, even this seemingly straightforward rule gives rise to hard cases. Software, for instance, presents a challenge. Courts have traditionally interpreted the UCC's requirement of movable to imply that goods must be tangible. Downloadable software, being intangible, has generally been excluded from the scope of Article 2. While a clever student might argue that downloading software involves the movement of electrons, courts reject this argument because the electrons themselves are not the subject of the contract and are not identifiable as the specific content of the transaction. However, what about software sold on a disk? Some courts hold that such software qualifies as a good because the disk is a tangible, movable object that embodies the software, much like a book is a tangible embodiment of the ideas within it. Other courts take a more formalistic approach, focusing on whether the predominant purpose of a transaction is the sale of the tangible medium or the licensing of the software. Still, others adopt a more pragmatic view, considering how the parties structured the transaction and the relative value of the tangible and intangible elements. These differing approaches lead to inconsistent interpretations, demonstrating that even under the uniform commercial code, variations in interpretation among states preserve some federalism within contract law. The UCC does occasionally resolve potential ambiguities through explicit provisions. For example, the UCC declares that the unborn young of animals and growing crops are goods, even though they may not be identifiable or movable at the time of contracting. This explicit inclusion avoids disputes over whether such items fall within the scope of Article 2. A similar explicit resolution could be applied to software, but efforts to address this issue have universally failed so far. Attempts to expand the UCC to address software and other digital products, for example, through the proposed Article 2B or the Uniform Computer Information Transactions Act, have been controversial and remain largely unadopted. Thus, the treatment of software and other digital goods continues to be shaped by state judicial interpretation. The UCC was a groundbreaking effort to unify commercial law across the United States, and Article 2 remains central to contract law for the sale of goods. However, as the treatment of software demonstrates, the evolution of technology and commerce often outpaces legal frameworks. Students of contract law must navigate these complexities, understanding both the UCC's provisions and the interpretive variations that arise in practice. Part E. Why does contract law exist? Contract law is private law. As discussed earlier, private law governs relationships between individuals, as opposed to public law, which addresses relationships between individuals and the state. The Roman jurist Domitius Oppianus famously explained, private law exists for the benefit of the individual. Contract law embodies this principle by enabling individuals to make binding agreements that enhance their lives through cooperation and trade. However, the maxim pacta sunt servanda, promises will be kept, is not strictly true as a matter of law. While courts never impose contract liability without some promise, not all broken promises result in legal liability. Why does the law enforce certain promises and not others? Legal scholars and courts have developed several theories to answer this question. There are four core justifications for why contracts are enforced: economic efficiency, reliance, autonomy, and fairness. While there are many others, these four justifications provide a comprehensive understanding of contract law's purpose. 1. Economic efficiency. Economic efficiency is one of the main reasons why contract law enforces promises. Enforcing contracts helps people make voluntary trades that leave both sides better off. When people make agreements, they do so because they expect to benefit from the exchange. Contract law ensures either that promises are kept or that the party who breaks a promise compensates the other for their loss. This reliability makes trading and planning easier and more effective. For example, imagine someone buying a loaf of bread at a bakery. Economics assumes the buyer values the bread more than the money they spend, while the bakery values the money more than the bread it sells. Both sides gain from this exchange, otherwise, they would not agree to it. This kind of mutually beneficial exchange is called a gain through trade. By enforcing promises, contract law facilitates gains through trade that would not otherwise occur. Everyone is made better off. Not all trades happen immediately. Many agreements are performed over time, and this is where contract law becomes particularly important. Consider an apple farmer in Washington state and a walnut farmer in California. The Washington apple farmer's harvest is ready in September, but the California walnut farmer's harvest will not be ripe until late October. Without the rights and remedies of contract law, these farmers might not trust each other enough to trade. The apple farmer might worry about shipping apples in September without a guarantee that walnuts will arrive in October. Contract law solves this problem by making promises enforceable. If one farmer breaks the agreement, the other can go to court to recover the value of the deal. This assurance allows both farmers to trade confidently. The apple farmer avoids wasting surplus apples, and the walnut farmer enjoys fresh apples along with their nuts. Both are better off because contract law enables them to rely on the agreement. Contract law does more than help individual farmers. It also encourages investments that benefit others. The apple farmer might plant more trees, knowing that there is a reliable market for surplus apples. The walnut farmer might expand their orchard, confident that they can trade extra walnuts in the future. These investments mean more crops are grown, fewer resources are wasted, and both farmers profit. By enforcing promises, contract law helps people exchange goods and services in ways that improve everyone's quality of life. Economists would consider this an increase in social welfare, meaning that society as a whole becomes better off. Economic efficiency does not justify enforcing all contracts, however. Other reasons may influence courts to enforce or not enforce promises. 2. Reliance. Reliance is another important justification for enforcing promises through contract law. Reliance theory focuses on protecting people who act in reliance on a promise, especially when breaking that promise actually causes harm. When someone makes a promise and another person reasonably relies on that promise to their detriment, contract law can step in to prevent unfair outcomes. The focus is not on encouraging efficient promises, but rather on compensating for harms caused by broken promises. Imagine a homeowner hires a contractor to renovate their kitchen. The contractor promises to start work next month, so the homeowner tears out their old cabinets and appliances to prepare for the project. If the contractor does not show up, the homeowner is left with a torn up kitchen and no way to cook. Reliance theory explains why the law might enforce the contractor's promise and give the homeowner a remedy. By protecting the homeowner from being harmed by the contractor's broken promise, the law makes it safer for people in the homeowner's position to rely on others' promises and to take significant actions based on them. This protection is not limited to commercial transactions. Reliance theory also applies in everyday situations. For example, imagine a student promises to babysit for a family on Saturday night. Relying on this promise, the parents buy movie tickets and make dinner reservations. If the student cancels at the last minute, the family might lose the money they spent and have to change their plans. While this may seem like a small matter, reliance theory shows how even everyday promises can affect people's lives. Enforcing these promises where appropriate ensures fairness and prevents unnecessary harm. Reliance theory is the main justification for the legal doctrine of promissory estoppel. As you will learn, promissory estoppel allows courts to enforce promises even when there is no formal bargained for exchange and thus no gain through trade. For promissory estoppel to apply, the person seeking a remedy must prove they reasonably and foreseeably relied on a promise, that this reliance was detrimental to them in some way, and that justice requires enforcing the promise. By protecting the interests of people who reasonably rely on promises, contract law creates stability and encourages trust. It allows people to take risks and make big plans without fear of being unfairly harmed by broken commitments. Reliance theory ensures that contract law serves not only economic goals, but also the fundamental need for fairness in human relationships. 3. Fairness. Some view contract law as a means to ensure fair outcomes. This fairness based justification for contract law focuses on preventing exploitation and protecting vulnerable parties, while other theories emphasize economic efficiency or the sanctity of promising. Fairness theory seeks to ensure that agreements themselves do not lead to unjust harm. The roots of fairness theory can be traced to the courts of equity. These courts were created to address cases where strict legal rules produced unfair results. Equity allowed judges to provide remedies based on principles of justice rather than rigid rules. Fairness theory follows this tradition. It allows courts to intervene when enforcing a contract would lead to an unjust outcome. Consider a tenant who signs a lease with a landlord. The lease allows the landlord to evict the tenant without notice or cause. The tenant agrees because they have no other housing options. This agreement might be valid under strict legal rules, but fairness theory, like equity, would question whether it is just. A court could strike down the clause to ensure the tenant is not unfairly harmed. Fairness theory is especially important in cases involving power imbalances. Large corporations often draft contracts that consumers cannot negotiate. These so called contracts of adhesion are presented on a take it or leave it basis, with no ability to remove or adjust the terms. Fairness theory supports doctrines like unconscionability, which allows courts to refuse enforcement of one sided terms. In this way, fairness protects weaker parties in contractual relationships. Fairness and equity share a common goal: achieving justice. Both accept that flexibility is sometimes necessary to address unique cases. By prioritizing justice, fairness theory ensures that contract law serves society's broader interests. It reminds us that contract law is not just about enforcing promises. It's also about ensuring that those promises align with principles of justice and equity. 4. Autonomy. Autonomy theory views contract law as a way to respect individual freedom and personal responsibility. It is rooted in classical liberalism, a philosophy that values personal liberty, individual rights, and limited government interference. Classical liberalism assumes that people are best equipped to make decisions about their own lives, including the commitments they choose to undertake. Autonomy theory applies these ideas to contract law, treating contracts as voluntary agreements that reflect personal choice and self determination. Autonomy theory treats the very act of promising as morally significant and as an expression of self. Honoring a promise respects both the dignity of the person making the promise and the person relying on it. Another key part of autonomy theory is mutual consent. Contracts are only valid when all parties voluntarily agree to the terms. This means the law will not enforce a contract formed through coercion, fraud, or deceit. For instance, if an artist is tricked into signing an agreement selling a painting, autonomy theory would argue against enforcement. By requiring genuine consent, contract law protects individual freedom and ensures fairness in agreements. 5. Additional theories. While the core theories of contract law, economic efficiency, reliance, fairness, and autonomy, provide foundational justifications for enforcing promises, additional perspectives offer important critiques and insights. These perspectives highlight the complexities of contractual relationships and the broader societal implications of contract law. Relational contract theory emphasizes the importance of context and relationships in contractual agreements. Relational theory considers contracts as part of ongoing relationships. Distributive justice theory focuses on how contract law affects social and economic inequalities. It argues that contract law should not only enforce private agreements, but also consider the broader implications for fairness in society. Critical legal studies critiques contract law as a tool that reinforces existing power structures and privileges. It argues that the law often masks inequalities by treating parties as if they have equal bargaining power when they do not. Behavioral economics challenges the assumptions that individuals always act rationally in making contracts. Cognitive biases, lack of information, and pressure can lead people to make decisions that are not in their best interest. Moral and ethical theories emphasize the intrinsic value of keeping promises. From a moral standpoint, breaking a promise is inherently wrong, regardless of economic or practical considerations. According to this view, contract law should reflect ethical values like trust, integrity, and mutual respect. Utilitarian theory argues that contract law should aim to maximize overall happiness or social welfare. Enforcing contracts creates predictability and trust, which supports economic growth and cooperation. These perspectives enrich the understanding of contract law by addressing areas the core theories may overlook. 6. Theory meets practice. Theories of contract law help explain why promises are enforced and how the law balances competing values. These theories reveal the deeper purposes behind legal rules, such as encouraging economic cooperation, protecting trust in relationships, and ensuring fairness in outcomes. While this book focuses on what contract law is, understanding these theories offers critical insights into its structure and evolution. Theories also highlight the inherent trade offs in contract law. Should the law prioritize predictability for businesses or fairness for individuals? Should it honor personal freedom or guard against exploitation? These questions are not always explicitly addressed in court decisions, but the theories provide a lens for understanding how courts navigate these tensions. Lawyers who better understand these theories are better able to sway courts to resolve these tensions in favor of their clients. Part F. Objectivity and subjectivity. When courts interpret contracts, they must decide whether to focus on the external evidence of what the parties expressed or the internal understanding of what they intended. These two approaches, the objective view and the subjective view, reflect contrasting philosophies about the role of law in interpreting human relationships. They are called views rather than theories because they describe practical methods for interpreting agreements rather than broad explanations of why promises are enforced. The objective view relies on external evidence, what the parties said, wrote, or did to determine their agreement. Courts favor this approach because it promotes predictability and stability. If parties know their expressed words and actions will govern, they can draft contracts with greater confidence and avoid costly disputes. Written agreements, in particular, are often interpreted based on their plain meaning, with little room for evidence outside the four corners of the document. This approach simplifies the court's role and reduces the potential for subjective or biased decisions. By relying on what a reasonable person would understand from the language of the contract, courts create a stable framework for interpreting agreements, especially in commercial contexts. In contrast, the subjective view focuses on uncovering the actual intentions of the parties. This approach considers all available evidence, including context, conduct, and negotiations, to determine what the parties truly meant. While this method can produce fairer outcomes in some cases, it also introduces uncertainty, as courts must evaluate conflicting evidence and determine whose understanding to prioritize. For example, imagine a buyer and a seller sign a contract for the sale of 100 widgets. The buyer later claims that during their private negotiations, the seller explicitly told them that widgets referred to a specific, rare type of high quality product. However, the written agreement simply says widgets without any further description. Under a full blown subjective approach, the court might admit not only evidence of the verbal agreement, but also the buyer's personal testimony about their private understanding of what widgets meant, even if that understanding was never expressed to the seller. The court might prioritize the buyer's asserted intentions, viewing the meeting of the minds as requiring alignment with the buyer's subjective interpretation of the term. Such an approach, while potentially fair to the buyer in this scenario, creates significant uncertainty and undermines the stability of contract law. It forces courts to engage in speculative inquiries about individual parties' unexpressed thoughts, which makes it harder for other parties to rely on contracts as binding agreements. No significant American jurisdiction today adopts this extreme form of subjectivity. Courts recognize that contracts depend on mutual understanding, but they generally require that this understanding be evidenced through outward expressions, words, conduct, or context. While the subjective view does influence modern contract interpretation in specific circumstances, especially in formal agreements or cases involving unique contexts, courts typically balance subjective evidence with objective standards to maintain fairness and predictability. These two approaches are best illustrated by two influential figures in contract law: Samuel Williston, who championed the objective view, and Arthur Corbin, who advocated for a more subjective approach. Their contrasting philosophies revealed the strengths and limitations of each method, and their influence continues to shape how courts interpret contracts today. Samuel Williston, 1861 to 1963, was a prominent legal scholar and a professor at Harvard Law School. He is best known for advancing the objective theory of contracts, which focuses on external expressions of intent. Williston argued that courts should rely on what the parties said and wrote, not on their unspoken thoughts. This approach promotes clarity and predictability in contract interpretation. Williston's treatise, The Law of Contracts, 1920, was foundational to the objective view. He emphasized that the meaning of a contract should be determined by how a reasonable person would interpret the parties' words and actions. This minimizes the role of subjective evidence, such as private intentions or unverifiable testimony. Williston believed this approach makes contracts more reliable and easier to enforce. As the reporter for the first restatement, Williston codified his objective principles. The first restatement directed courts to interpret contracts based on their plain language and to avoid extrinsic evidence unless ambiguity existed. This reinforced the idea that contracts should be judged by their expressed terms. Williston also distinguished between written and oral contracts. He argued that oral contracts, like those in writing, should be strictly interpreted according to their language. Oral agreements, however, might require some flexibility to account for context. Despite this distinction, Williston consistently prioritized objective evidence over subjective intent. Williston's work had a lasting influence on contract law. His objective approach remains central to how courts interpret contracts, particularly in commercial settings. By focusing on expressed intent, Williston helped create a legal framework that values stability, efficiency, and fairness. Arthur Linton Corbin, 1874 to 1967, was a leading legal scholar and professor at Yale Law School. He is best known for his treatise, Corbin on Contracts, first published in 1950. Corbin's work shaped modern contract law and heavily influenced the Second Restatement. Corbin advocated a flexible approach to contract interpretation. He believed that courts should consider the context of an agreement and the parties' actual intentions. While he recognized the value of external evidence, he argued that relying solely on it could lead to unfair outcomes. In Corbin on Contracts, he emphasized that the meaning of a contract cannot always be determined by its plain language. Instead, courts should examine the circumstances surrounding the agreement. Corbin urged courts to uncover what the parties truly intended, even if their intentions were not perfectly expressed in writing. Corbin's views shifted contract law toward a more realistic and relational perspective. His influence is clear in the Second Restatement, which reflects his belief that contracts must be interpreted in light of their context. Unlike Williston, Corbin did not insist on strict adherence to formal language. Instead, he sought to balance fairness and predictability. Corbin's legacy is his emphasis on achieving equitable outcomes. His approach remains a key part of modern contract law, whose aim is to ensure that agreements reflect the actual understanding of the parties when evidence supports it. Today, courts generally adopt a balanced approach to contract interpretation, one that blends elements of both the objective and subjective views. This modern approach seeks to balance the predictability and stability provided by the objective view with the fairness and flexibility offered by the subjective view. Courts typically start with the objective approach. They first examine the plain language of the contract, focusing on the words and actions that a reasonable person would interpret as expressing the party's intent. This provides a clear, stable framework for enforcing agreements, especially in commercial transactions where certainty is crucial. However, where contracts are ambiguous or when external circumstances suggest that the written language does not reflect the party's actual understanding, courts may look beyond the words on the page. In these cases, they admit subjective evidence, such as negotiations, conduct, and the broader context of the agreement, to discern the party's true intent. This ensures that contracts are not enforced in ways that lead to unjust or absurd results. For example, a court interpreting a contract for delivery by December 1 might initially assume that that phrase refers to the calendar date. But if evidence shows that both parties understood it to mean the first shipment date in December, the court may adopt that interpretation to reflect the parties' shared intent. This mix of objective and subjective analysis helps courts align contract enforcement with practical reality. The second restatement reflects this modern approach. While it begins with the presumption that contracts should be interpreted based on their plain language, it acknowledges that courts may need to consider external evidence in certain situations. The second restatement encourages judges to interpret contracts in ways that uphold both the reasonable expectation of the parties and the practical needs of the transaction. The modern approach also reflects the influence of economic, relational, and fairness theories. It recognizes that contracts do not exist in isolation, but are shaped by their surrounding circumstances and the relationships between the parties. Courts often tailor their interpretation to ensure that agreements are enforced in ways that promote trust and cooperation. While this approach seeks to strike a balance, it is not without criticism. Some argue that allowing subjective evidence undermines predictability, particularly in commercial contexts. Others contend that relying solely on objective evidence risks ignoring the realities of human relationships. The modern approach attempts to navigate these tensions by combining the strengths of both perspectives. By blending objective principles with subjective flexibility, the modern approach ensures that contracts are interpreted fairly and predictably. It reflects contract law's evolution into a system that balances individual rights, economic efficiency, and relational fairness. Part G: Reflections on Contract Law. Contract law has developed over thousands of years to meet humanity's need for trust and cooperation in trade. For millennia, courts have enforced private agreements, thereby encouraging commerce and fostering trust, even among strangers. This essential function remains unchanged, though the doctrines and details continue to evolve. Rooted in Roman law and carried through the Norman conquest to England, contract law merged with local custom to address the needs of growing societies. The American colonies inherited this legal tradition, but adapted it over time, developing distinct approaches as the distance from England and the demands of a new nation shaped its evolution. Despite these historical shifts, the core purpose of contract law has endured. It remains a system of voluntary liability that supports individual autonomy and economic cooperation. Central to its philosophy are two enduring principles: freedom to contract, the right to make binding agreements, and freedom from contract, the right not to be bound without consent. These principles reflect the balance that contract law strikes between promoting personal choice and ensuring accountability. While the purposes of contract law have stayed consistent, its nuances and doctrines continue to change. As society and technology evolve, so too do the challenges that courts must address. Additionally, because contract law is primarily state based, its development across the United States has created a patchwork of variations. These differences enrich the field, but can also make it harder to identify universal principles. This course aims to simplify that complexity. By focusing on the common threads of American contract law, it emphasizes the foundational principles that transcend state lines. The goal is to equip students with a clear understanding of what contract law is, while leaving space to explore how it continues to adapt to new circumstances. The enduring legacy of contract law lies in its ability to balance competing values: individual autonomy and fairness, predictability and flexibility, personal rights and collective trust. As you study these principles, you are engaging with more than just legal rules. You are exploring the framework that shapes human cooperation, trade, and the economic relationships that sustain society.